Anyway, one of the people in that band was a person called Ian Pay. He was the drummer. He had joined the group of people doing these shows towards the end of 1990 and the early part of 1991. He was part of the Serious Fun, and then he became a performer at the Astor Place show. And although he didn't really claim to and didn't write any actual melodies or harmonies, because that doesn't work on a drum set. He was credited with a share of the music composition for the songs that were incorporated into the show, and which was then very successful, went on to get sellout crowds, continued for 3 years. And for those who may be familiar with Blue Man Group, either from seeing it or from reading about it or seeing it advertised on TV, it's ended up spreading all over the world. It's spread to 2 other cities, Boston and Chicago, quite quickly, and then to Las Vegas. And it continues to run in New York, Boston, Chicago, Las Vegas, Orlando, and in Berlin, Germany, to this day. The founders of the group are very proud to announce that they've never closed an American show. So the case arose when the plaintiff wrote letters starting in 2014 claiming that the amount of the royalties that he was receiving from the music that was in the show was dropping, and in 2014 it dropped quite suddenly because of an internal accounting that reevaluated what music was in which show. And in the spring, in September of 2014, he wrote a letter saying, I want to have a written agreement, because there wasn't a written agreement concerning the payment of royalties in the music. You can see where this is going, I can imagine. So that didn't result in any agreement, and in the spring, May of 2016, he filed a lawsuit. There weren't any work for hire agreements, at least there weren't one that the company could find that Mr. Pay had signed. The work for hire agreements that various people involved with the production and other musicians had signed. And because of the years that they'd worked together in the opening of in the early years of the show, in particular in the period leading up to the opening of the show at Astor Place, Mr. Pay and his counsel asserted a claim of breach of fiduciary duty and wrote a very detailed, over 35-page, I think, complaint describing the closeness of the relationship and saying that by virtue of this, there was a fiduciary duty owed by the 3 individuals whom I mentioned, the founders, Matt Goldman, Chris Wink, and Phil Stanton, to Mr. Pay. And that was also used by the plaintiff's counsel as a basis to say that because of the fiduciary duty, the plaintiff was able to disregard the statute of limitations and claim for damages, namely additional funds that he should have been paid by virtue of the duty that he said was owed to him, back over 25 years. And as a result, that put together a claim that they stated in their complaint as 125 million, plus they said it was so outrageous that there were punitive damages. I'm betraying my loyalties here. And what we did in defense was, well, first, because of the breach of fiduciary duty claim, although it was in the nature of a music royalty dispute, we notified the carrier saying, well, the individuals, one of whom was no longer employed by the company but was a founder, are covered by the directors and officers liability claim. So that resulted in a fairly satisfying win on a motion to dismiss, because we said just the closeness of the personal relationship is insufficient to state a claim for breach of fiduciary duty. for anyone who deals with these sorts of disputes between people who have founded a company or have worked together for a long time, you should be aware of this, because there is a small but significant line of cases in which the courts have said, alleging that degree of closeness of fiduciary duty can state a claim. And the case in New York is Apple versus Capitol Records, first decided in 2000, actually earlier than that. The subsequent decision is in 2005. 13 MISC 3D 1211 is the citation of that. That case was a claim by the Beatles against its longtime music publisher and record company, Capitol Records, saying that they'd maintained the masters of the Beatles recordings. Probably it's hard to imagine a more valuable set of masters that could be bailed from the bailor, the members of the Beatles to their record company, and that the record company had made additional monies from reproducing those masters which had not been reported according to the recording agreements in place. So that line of cases resulted in the breach of fiduciary duty surviving a motion to dismiss, but the judge, Justice Ostrager, who previously was the head of litigation at Simpson Thacher here in New York, ruled that the theory that the plaintiff could go back in time by virtue of the existence of a fiduciary duty did not work. That works for an equitable claim, but not a damages claim, and it works in the event of an appointed fiduciary, like a trustee in bankruptcy, a trustee, an executor, something like that. So basically, we managed to get a lot of the value of the claims dismissed right at the outset.